Good afternoon, all, and this is going to be a short video to bridge a gap between my last video and my next video. This video has to do with homogeneity of a group, and in Haley Moss's Florida Bar Neurodiversity Continuing Legal Education, CLE, the traditional position of the Florida Bar and the Florida courts was stated as great minds think alike. That's the historical membership composition of the types of people in Florida that populate or have populated historically the Florida Bar's membership and the judicial membership and courthouse employee membership of the courts within the state of Florida. And so this is really significant because today I want to review and cover a blog post I found on Quora. Let's go. Homogeneity is the quality or state of being all the same or all of the same kind, such as the cultural homogeneity of our society. And this is just a definition pulled up on Google that comes from Oxford Language. And so when you talk about the homogeneity of the membership of the Florida Bar and the state and federal courts within the state of Florida, you're talking about the cultural homogeneity of the officials and memberships and employees being all the same or all of the same kind. That is, they are all of the same neurotype. And that is that if we review the articles about Haley Moss, the first openly autistic lawyer in Florida, where Haley Moss herself wrote on a HuffPost that she was the first openly autistic attorney in Florida in early 2019. Well, from that fact, assuming it's true, from that fact, then we can calculate that given that the Florida Bar says it has over 111,000 licensed lawyers, that if Haley Moss was the first openly autistic lawyer admitted to the Florida Bar, and that was as of early spring 2019, then from that, we know that certainly up until that point, and no doubt continuing thereafter, what that tells us is that the Florida Bar has homogeneity in the composition of its bar membership, meaning non-autistic, that it's a homogenous neurotypical bar membership. And since bar membership is oftentimes an eligibility criteria for someone to obtain a judge position in either the state or federal courts of the state of Florida, because Florida Bar's membership has neurotypical homogeneity, then that means so does the membership of the judges in the state and federal courts within the state of Florida. We can calculate that. We can ascertain that, and that is knowledge that is knowable that we know. In this neurodiversity continuing legal education here, put on by the Florida Bar, that I reviewed and took some clips from in my very last video, and you can refer to that video on my channel. The tradition, the historical tradition of the Florida bar was stated by the CLE provider to be the concept that great minds think alike. That is a neurotypical cultural concept. That is the opposite of being autistic. Because as Haley Moss states in that CLE on neurodiversity, the neurodiversity concept is great minds think differently. And so we have to ask ourselves, well, if decades and decades of this historical tradition of the neurotypical homogeneity of membership composition in the Florida bar that percolated up into the state and federal courts within the state of Florida was one of neurotypical homogeneity, the cookie cutter concept that great minds think alike, then when this social group of these lawyers and court people within these courts within the state of Florida hired law clerks, judicial assistants, courthouse clerks and employees, and so on and so forth, what kind of people do you think they hired? Well, the Florida Bar's neurodiversity CLE provider, Christine Bilbrey, I believe it was Christine, but the providers were Christine Bilbrey and Jamie Moore, stated that the historical tradition was great minds think alike. Those are the people they hired. They hired people like them, people who are neurotypical. So what you have is a deep South bar and bench that is composed of membership, officials, law clerks, judicial assistants, courthouse personnel, clerks, and courthouse employees that are neurotypical and that have neurotypical homogeneity. Now, why does that matter? Well, let's go to a post I pulled up on Quora entitled, "What is it like clerking for a judge? Advice to prospective clerks." And I obtained this post on March 31st, 2024 personally by going on the internet and going on Quora and finding this post here. And this post was written by someone calling themselves under their identity avatar as Alice Baker, former law school professor, 2001 to 2008, with a Juris Doctorate degree, a JD, in law from Washburn University in 2004. We don't know any more than that about this poster, but that's how the poster identified themselves here. And this was posted on a thread on Quora called, "What did serving as a judge's law clerk in a U.S. court teach you about the way the system works in the U.S.?" And here's what she had to say. "You should be nice to the law clerks. Law clerks and everybody else on the judge's staff, for that matter, have far more power than many people who have not worked in courthouses realize. In many ways, they serve as gatekeepers to the judge. Also, law clerks are creative. If you're a lawyer, a law clerk who does not like you can and will come up with 100 different ways to make your life miserable. Smart lawyers treat the judge's staff like gold. That's number one. Number two, lawyers get away with far less than they think they do. If you miscite a statute, regulation, or reported opinion in a written brief, the law clerk will catch it. If you quote a portion of a statute, regulation, or reported opinion out of context in a way that misrepresents the content, the law clerk will catch it. If you try to use outdated precedent that is no longer valid, the law clerk will catch it. If you pull a sleazy stunt, the law clerk will catch it. If you fudge either the facts or the law in a written brief, you will be caught. You will instantly lose credibility with the judge, and the judge's staff collectively has the memory of an elephant. Story time. I clerked in a federal courthouse located in a Midwestern city where I had never lived before. When I arrived at the courthouse on my first day of work, the only people in town I knew were the courthouse personnel I had met during my job interview and the realtor who sold me my house. The judge's secretary gave me my first assignment. She handed me the file for a case with a pending motion and said, "The judge wants you to look at this." Then she pointed to an attorney's name on the docket sheet and said, "Watch out for this one. You can't trust him." I have never forgotten how quickly I learned which local attorneys could and could not be trusted. 3. There are no secrets in a courthouse. The federal courthouses have world-class grapevines. Would you like to know what happens if a law clerk catches an attorney intentionally misstating the governing law in a written brief filed with the court, or pulling some other kind of sleazy stunt? This is what happens. Within 30 seconds, the law clerk carries the written brief into the other law clerk's office and says, "You won't believe the stunt Sleazy Slickerman tried to pull this time. Look at this." Within 10 minutes, the law clerks have informed the entire chamber staff about Slickerman's defalcation. Within 1 hour, the judge's secretary has told every other secretary in the courthouse the story. Within 2 hours, the courtroom deputy has told everyone in the office of the clerk of courts the story. Within 3 hours, the law clerks have told every other law clerk in the courthouse the story. Within 24 hours, the judge has told every other judge in the courthouse the story. The only person who will not be informed that Mr. Slickerman got caught doing something sleazy is Mr. Slickerman himself. Mr. Slickerman usually goes on happily through life, blissfully unaware of the derogatory nickname by which he is known among courthouse personnel. One of the attorneys who regularly appeared in our courthouse was known behind his back as the Weasel. I got to the point I couldn't remember the guy's actual name. And this post was posted on Quora. Okay. So, you're an autistic person and you're out there surfing the internet. Like anybody can do this. And you come across a law clerk to a judge posting on Quora about how there's this gossipy grapevine that runs between all the different judges in the courthouses, clerks and judicial assistants, the clerk of the court, and the courthouse personnel, everybody within the court, where anything that is not cookie cutter alike, anything that is atypical, that is abnormal, that is weird, quirky, unusual, or odd, goes through the grapevine like wildfire, and everybody knows about it, and everybody's talking about it ex parte communication within the courthouse that's outside the record of a litigant or party's case. Now, it'd be absurd to say that this courthouse grapevine making this ex parte communication and many times towing the line of neurotypical homogeneity and outing anything that is abnormal, atypical, unusual, weird, or odd, or different, and spreading it throughout the courthouse to everyone, including all the judges. It'd be absurd to think that it only operates upon licensed Florida bar members or licensed bar members wherever they may be. We know better than that. We know neurotypical social types. We know their social culture. At least many autistic people have tried to study it because we don't have that social cognition, and we always make social misspeaks or social faux pas, and we can't dance the social dance, so we are constantly being complained and condemned and punished, invalidated, and told we are broken by neurotypicals because of it. So we know how neurotypical social society operates, and no autistic person would believe that this courthouse grapevine that a law clerk to a judge just went out and blah, 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 blah all over the internet about it on Quora spoke about. So why is this important to autistic people? Well, because when the clerk was talking in this post about the courthouse grapevine, she's talking about making what the neurotypical homogenous courthouse group perceives as a misstatement or misinterpretation or even a misunderstanding. Oh boy, you can't make that kind of courthouse grapevine confession all over the internet, blabbing it all over the internet without providing the confession of a piece of circumstantial evidence that would affect autistic people and affect us in a negative way, particularly as to the outcome of losing our cases in all of the courts. So let's see why. Well, for that we have to go to Bill Nason's autism discussion group and to his post on relating on two different planes. Literal versus perspective taking. This is about the differences in the neurotypical language and the autistic language. Let's see what he has to say. Relating on two different planes. Neurotypical people, when interacting, naturally look for the intent and perspective of the other person to give meaning to their words. We read between the words to understand the thoughts, feelings, and perspectives of others. We are looking at intent, why they are saying what they are saying. We frequently read more into what is being said than the literal words. However, people on the spectrum tend to speak very literally. What I say is what I mean, with little inferring or reading between the words needed. Since neurotypical people are used to inferring intent for people on the spectrum, if their intent is not clear or obvious, neurotypical people will project or infer intent to them. Of course, this inferred intent often does not match what the autistic person on the spectrum truly means. This gets everyone into trouble. On the one hand, the person on the spectrum is not reading the hidden meaning of neurotypical people, and neurotypical people are misreading too much hidden meaning behind the literal words of those on the spectrum. Difficulties behind communication. Neurotypical people speak with multiple meanings and intentions, often with hidden meaning. Rarely is our communication literal to the word. Also, neurotypical people usually assume that the same process occurs for people on the spectrum, so they often infer certain perspectives and intentions in the person with autism that are not there. For example, the person with autism is often blunt and literal, saying it as it is. This often offends neurotypical people as rude and disrespectful, although there is no intent on the part of the person with autism to be rude and disrespectful. In turn, people on the spectrum speak very literally, often meaning exactly what their words are saying. Consequently, they often read the language of others very literally, missing the hidden meaning behind the words, perspective, and intention of others. So we are speaking on different planes. Neurotypical people are speaking on a perspective-taking plane of interaction, and people on the spectrum are speaking on a literal plane. No wonder there is frequent misunderstanding. Now, neurotypical people feel the main disability is that people on the spectrum cannot understand where they are coming from, perspective of those on the spectrum. They read too much into the intent of people on the spectrum. They read intent when that intent is not there. We have just as much problem reading the thoughts, feelings, and perspectives of those on the spectrum as they have with us. We are relating on different planes, both often missing the intent of the other. When talking with adults on the spectrum, this issue arises a lot. It is central to them living comfortably with others. This misunderstanding on both sides leads to major problems in communicating and relating. When relating with those on the spectrum, don't assume they understand your perspective. And so what you have going on is that this courthouse law clerk grapevine that's running throughout the courthouse, all the judges, assigned all the cases, the court clerk, all the court staff, everyone in the courthouse, who obviously have at least historical tradition of great minds think alike, they have neurotypical homogeneity. So as this clerk posted on Quora, if the neurotypical clerk perception of the law clerk assigned to the autistic person's case in the court perceives the autistic person as making a misstatement or a misinterpretation, which you can see the danger and the problem here, is that this neurotypical law clerk of all these kinds of law clerks, the homogeneity of these law clerks they hire in these courthouses don't have any specific autistic training and education. They're not using any kind of an autistic language interpreter and translator, then they're going to communicate on two different planes, literal versus perspective taking. And so these neurotypical law clerks are going to project meanings, feelings, and perspectives, or intent and perspectives of the neurotypical type onto the autistic person, the party or litigant that isn't there. It's wrong. What it is a misunderstanding. But as this law clerk who blabbed all over Quora on the internet is saying, these neurotypical homogenous law clerks will take their misunderstanding as the autistic person being Sleazy Slickerman. And then they will gossip throughout the courthouse. And you know what happens then. What happens is it's a disaster for everyone. because the autistic person is being denied a fundamentally fair and impartial trial or hearing. And because there's fundamental unfairness in their case, it denies due process of law. And not only that, ex parte communication and contact is prohibited. It's a violation of judicial ethics. And this is happening. And this law clerk who blabbed all over Quora is confessing this is happening. And so I'm doing this video on this because there's a communication gap going on within the gossip grapevine of these courts within the state of Florida, these state and federal courts. And it's involving law clerks, lawyers, court clerks, and courthouse employees, and the judges themselves. And this grapevine is gossiping about, in some cases, autistic litigants. And this is having a very hostile and negative effect on the autistic person, the litigant, who then loses their case because of these misunderstandings, misinterpretations, and misimpressions of their autistic nature, their being autistic, their autistic language, and is actually misinterpreting what the autistic person actually said. So, this is what's happening. It's very important to understand this. And this is actually a part of the reason that the Florida Bar's neurodiversity CLE should be made mandatory upon every single licensed lawyer in the state of Florida and every single state and federal judge serving on the bench, on any bench within the state of Florida. So this video is simply to bridge the gap between my last video that I just published and my next video, which is going to be on the topic of when a rogue band of Florida lawyers and other lawyers stalk an autistic person to blogs and internet forums and post under anonymous IDs, and then they get very upset with the way the autistic person communicates, and they're misinterpreting that autistic person and misunderstanding that autistic person. The sum gem you have to pull from this, from what they say, is it's not the content of what the autistic person is communicating. It's the way in which she says it. And that is the topic of my next video. So if you liked this video, please hit the subscribe button and the notification bell, and you'll be notified of my future videos. Thank you for watching.